Indeed, I would add to that the conspiracy charge here, Justice Kennedy, is the problem with it is compounded by the fact that the tribunal itself is charging a violation of the laws of war when the military commission has never operated to try violations of terrorism in stateless, territorialist conflicts. That is, it's not just the charge, but it's where the charge operates that we find so central. That they're two different things. There's two different
clear that
problems.
The charges against your client could not be amended?
They may be amended. Yes.
Then why should why should there be review before trial of a charge that could be amended? There could be additional charges added by the time there's a final decision.
And Justice Alito, the government has had essentially now 4 years to get their charges together on Mr. Hamdan. At this point, what you have before you is the charge, and they've stuck with this charge of conspiracy, which is not a violation of the laws of war, and indeed it's not just conspiracy isn't, but that the commission is operating in totally uncharted waters because it's charging a violation in a stateless, territorialist conflict, something as to which the full laws of war have never applied. Indeed, Justice Alito, all 10 people facing military commissions today, all 10 indictments charge conspiracy right now. 7 only charge conspiracy.
Isn't this contrary to the way legal proceedings and appeals are normally handled? You have essentially a pretrial appeal concerning the validity of a charge that may not even be the final charge.
Not here, because as I think both courts below indicated, this case and his challenge falls very much like Abney versus United States. This is a challenge to the lawfulness of the underlying tribunal and the charge that's against him. Indeed, this court in Kieran heard as its first question, does the charge state a violation of the laws of war? That was the first thing it said had to be asked. So I think what we are doing is applying nothing more than the settled practice that has always been the case with respect to military commissions. And in the public interest here, again, just as in Kieran, I think requires some limits placed on military commissions, Justice Alito, because otherwise, if the government's position is taken as the final word, it'll give the president the ability to essentially create that blank check for years on end, render a final decision at some point, and then that final decision will then be subject to the truncated review procedures in the DTA, which I don't think is what Congress intended when they changed the language of the bill. Rather, I think what they did was intend that this court would decide apply the basic structural limits on military commissions that have always applied.
I asked this question about the charge. The charge is not just conspiracy in the abstract, it's conspiracy to do specific things, one of which is attacking civilians and civilian objects. And is it clear that the commission would not have, a military commission would not have jurisdiction to try a conspiracy to harm civilians in a war zone, for example?
It is clear, Justice Stevens. That is precisely what the international tribunals reject. Conspiracy is a standalone offense. One can charge as a war crime attacking civilians and the like as a pure crime, but what you can't do is charge conspiracy. And indeed, the Congress of the United States in 1997, when they wrote the War Crimes Act, essentially made that conclusion because they defined war crimes with incorporating a variety of treaties.
Well, suppose that proof were to show that there was very substantial and knowing involvement, rendering him basically an accomplice or a principal, but it was still found under conspiracy. Would international law violate that? Assume that he's been given notice of during the course of the proceedings as to what the charges specifically are as the proof is adduced.
Justice Kennedy, on this particular point on conspiracy, yes, that you couldn't charge some other offense like aiding and abetting and transmute some conspiracy charge into that. Rather, the international law and the laws of the United States recognize you can prosecute him for aiding and abetting, as a violation of whatever the specific underlying crime is, like murder or attacking civilians. What you can't do is use the standalone offense of conspiracy, and here's why. Because the standalone offense of conspiracy is rejected by international law because it's too vague. And this Court has said that the test for a violation of the laws of war is when universal agreement and practice make it a violation. The world rejects conspiracy because if it's adopted, it allows so many individuals to get swept up within its net. Justice Kennedy, aiding and abetting requires a much closer relationship between the conduct and the individual offender. Conspiracy does not. And so, for example, under the government's theory, a little old lady in Switzerland who donates money to al-Qaeda, and that turns out to be a front for terrorist acts and so on, might be swept up within this broad definition of conspiracy. And that's why international law has so rejected the concept of conspiracy.
Well, let me put it this way. If we were to find that the Geneva Convention or other settled principles of international law were controlling here, why couldn't we just remand to the D.C. Circuit and let it figure that out? Or let it have the tribunal figure it out in the first instance, assuming the tribunal is properly authorized?
Well, it is the role of this Court to confine the tribunal to its lawful jurisdiction. That's what this Court held in Kieran, and that's what we think you should do here. The tribunal itself can't be the judge of its own jurisdiction.
Well, suppose we told the D.C. Circuit that the Geneva Convention or some other body of international law controls and just remand it for it to go into all these arguments.
Again, we think at this point that the public interest is best served by this Court saying that conspiracy doesn't violate, to set some limits. After all, everyone facing a military commission is facing this charge. 7 are only facing this charge. The government wants to put 75 of these cases through, and it has taken 4.5 years since the President's military order for this case.
This question. Supposing the charge had been slightly amended, instead of saying for the criminal purpose and conspired and agreed with Osama bin Laden to commit the following offenses. It had said it and Osama bin Laden attempted to aided and abetted in committing the following offenses. Would it then violate the laws of war?
If the charge is the specific offenses themselves, not aiding and abetting.
Well, the specific offenses are attacking civilians and attacking civilian objects.
Yes, with respect to this particular claim about conspiracy, that would solve that problem. If you say the charge is attacking civilians and your theory of proving it is aiding and abetting the murder or the attacking of civilians.
And then what if the trial judge who looked at the indictment, ruling on a motion to dismiss the indictment or its equivalent at this time, said, well, I'm going to construe these words conspired and agreed as a substantial equivalent of aiding and abetting. Would that let the charge stand?
That would mix apples and oranges, because conspiracy and aiding and abetting are two entirely different things. One is a standalone offense, and one is a theory of how to prove a violation.
But the language is conspired and agreed with is pretty close to tried to do it himself.
It's not, Justice Stevens, because it requires a different level of participation, and the liability is entirely different. Because if conspiracy is accepted, you're accepting Pinkerton liability. That's what the government's own charge said, the government's own instructions say, which means that Mr. Hamdan is liable for all the acts of 9/11 and everything al-Qaeda has done. Aiding and abetting, as you are saying, Justice Stevens, in your hypothetical, is a much more closely tethered theory of liability, requiring a higher level of individual culpability and a totally different level of punishment.
As I recall, the Sixth Amendment, you're entitled to know the charge against you, and you're saying that the charge of conspiracy is not the charge of aiding and abetting.
That is correct. If I could turn to a second argument for why we believe this military commission is impermissible, and that is that it defies the Uniform Code of Military Justice.